Good morning. I'm Jayashree here from my voice. We will continue with section 128 of CPC today. Okay? 128. Matters for which rules may provide. See, we have already seen that High Court has the power to make rules. Correct? For each for itself, for its subordinate courts. So, the High Court will be the one which is making rules. Okay, of course, everything is subject to the legislative sanction, but the High Court can make rules. Okay, so such rules shall not be inconsistent with the provisions of the body of this code. So here, which are the rules that we are talking about? As we already read in a few sections back, the rules that we are talking about here is the rules which come under CPC. Order 1, Rule 10, Order 1, Rule 9, Order 1, Rule 1. You have all these things in CPC, am I right? So these rules are made by the High Court according to, these rules are made according to the provisions of this code, and it shall be read as part and parcel of this code. We have already done it in a few previous sections. Again, we are doing it, okay? Now we will know which are all the areas in which the rules can be provided for. Okay? In particular and without prejudice to the generality of the powers conferred by subsection 1, such rules provide for all or any of the following matters. Or almost all the civil cases come under this. Am I right? Not almost all, almost every case which is filed on this of a civil nature, everything is following CPC. Everything has to follow the Code of Civil Procedure. The procedures there, right? Okay. In particular and without prejudice to the generality of the powers. So what is it? These are all the particular powers which are given. They can make a rule for which particular area. That is what it means. Okay. A. Service of summons, notice and other processes by post or any other means. We know what are all the means. Am I right? So by register post with acknowledgement due, or through court, or through tom-tom. Substitute service. That's what we call it nowadays. Not nowadays. Substitute service is what we call it, right? So, or rules regarding the processes, notices and summons. Rules can be made. That's why you have it in order 5. Am I right? Okay. We will not look at all those orders now. I'm just giving you an idea. That's it. Okay. So that you can relate to it. Then B. The maintenance and custody while under the attachment of livestock and other movable property, the fees payable for such maintenance and custody, the sale of such livestock and property, and the proceeds of such sale. See, movable property. This is speaking about movable property, something which is perishable also, because it is livestock. Okay. So the maintenance and the custody of the livestock. Okay. When the livestock has been attached, it's under an order of attachment. So whatever is the fees for maintenance and custody of the livestock, okay, the fees payable for such maintenance and custody and the sale of such livestock. We have already seen when the amount is realized out of the sale from attachment. The first one, what will be the expenses? The first expenses will be that of the execution. Am I right? So that's what is written here. That's why I told you, you should remember everything in a book. Okay. C. Procedures in suits by way of counterclaim and the valuation of such suits for the purposes of jurisdiction. We have the Suits Valuation Act. Am I right? So that is also one of the powers given. Okay. Then procedure in garnishee and charging orders, either in addition to or in substitution for the attachment and sale of debts. Okay. So who all, other than the attachment and sale of all the debts, who are all the other creditors to whom the amount has to be paid? The rules, how will it be given? To whom will it be given? How much will be given? How much obviously will depend upon the debt, but still calculations will be there. Okay, then next. Procedure where the defendant claims to be entitled to contribution or indemnity over against any person, whether a party to the suit or not. Okay, so where the defendant claims he is entitled to a contribution or indemnity. Defendant says, no, even though I am there. See, we were reading about interpleader suits, am I right? Wherever it is very clear who is the creditor or to whom the right is or the power is, it is very clear. We can just file a case against them. But if it is not clear, then interpleader suit has to be given, right? So I'm just giving you an example, a connection between this and that, where a defendant says that he has a claim, okay? He has a contribution or an indemnity over and against any person, whether a party to the suit or not. Then how will the rule be taken? Can the defendant take up the claim in the same suit, or he should file a different suit? Right? Whether it is related to the transaction for which the plaintiff has already filed a suit against the defendant. Can the other party, that is the person against whom the claim is being made, can that party also be made a party to this existing suit? There are so many such things, right? So all those rules will be framed. Then F, summary procedure. In suits in which the plaintiff seeks only to recover a debt or liquidated demand in money payable by the defendant with or without interest arising on a contract express or implied, or an enactment where the sum sought to be recovered is a fixed sum of money or in the nature of a debt other than a penalty. See, penalty cannot be recovered, right? Okay. Or on a guarantee where the claim against the principal is in respect of a debt or liquidated demand only. So this relates to recovery of money, okay? So you can just write there somewhere. In suits which the plaintiff seeks only to recover a debt or liquidated demand in money payable by the defendant with or without interest. So when we are filing a case for recovery of money, it can arise out of any type of transaction. You have it here. On a contract, whether it is express or implied contract. Number 2, on enactment where the sum sought to be recovered as a fixed sum of money or in the nature of a debt other than a penalty. See, something like land arrears and all that, or where the financial institution has given a loan and statutorily, sometimes what happens, tax is not paid, right? So whatever is given and on the basis of an enactment. Enactment means what? Act. Capital A, act, right? Okay. Then on a guarantee where the claim against the principal is in respect of a debt or a liquidated demand only. So on a guarantee means what? So the automatically you should assume that the person is a surety. Or on a trust. Very important. This is not T capital trust. This is out of trust. Or in suits for recovery of immovable property with or without a claim for rent or mesne profits by a landlord against a tenant whose term has expired or has been finally determined by notice to quit or has become liable to forfeiture for non-repayment of rent or against persons claiming under such tenant. So when is the next one? In suit for recovery of immovable property without collection of rents. The person who is filing the case, he just wants to recover the immovable property. He just wants to take back the immovable property. Okay, he is not worried about the rents which are due. He is not worried about any of the mesne profits. Mesne profits means what? Gained by illegal means. Am I right? So he is not claiming for anything. He is only claiming for immovable property by a landlord against a tenant. See, sometimes what happens, they say, we have been in possession for so long. Come on, this is adverse possession. This is a case of adverse possession. So I am not going to vacate. This is my house. Sometimes what happens, the person, more often than not, nowadays it's happening, right? Many people are abroad, settled abroad. So what they do, they say, you take care of the house. You be some sort of a tenant plus housekeeper types. Okay, you take care of the house, you just pay the rent to me, and after a few days, when the rent gets stopped, okay, the tenant doesn't pay the rent, even then the owner, that's the person who is residing abroad, doesn't get to know because they don't check. Okay. Later, when they realize that the property is going out of their hands, just because they receive a summons or notice from the court, when they realize that the property is going out of their hands, then all of a sudden they realize that the rent has been stopped by the tenant. Right? There are so many such cases, variety of cases which we can see, unfortunately. Okay. Then G, procedure by way of originating summons. Then H, consolidation of suits, appeals and other proceedings. Delegation to any registrar, protonotary or master or other official of the court of any judicial, quasi-judicial and non-judicial duties. So for these also the rules can be made. That's what they are writing down. Then all forms, registers, books, entries and accounts which may be necessary or desirable for the transaction of the business of civil courts. Simplest example, when we are filing, there's a filing register. Of course, nowadays you don't have any filing register or anything like that. Everything is given in the computer, everything is fed into the system. But still, in the register, we have to get the signature of the parties, not during this COVID season, otherwise than COVID. Okay. So you just keep it in mind. There will be books of accounts. Then there will be, there are so many transactions. Court fees is being paid. That has to be kept in this thing. So there are so many like this. Okay. Then Section 129, power of high courts to make rules as to their original civil procedure. So what does it speak about? It is the power of the high court to make rules for its own itself. For itself. Okay. The procedure which it has to follow while dealing with original cases. That is, High Court has original jurisdiction as well as appellate jurisdiction. Am I right? Reversionary. Of course, revisionary jurisdiction is also there. But when it is exercising original jurisdiction, what are all the procedure which has to be followed by the High Court? So, High Court has the power to frame those rules as well for itself. Section 130, power of other high courts to make rules as to matters other than procedure. A high court not being a high court to which section 129 applies may, with the previous approval of the state government, make with respect to any matter other than procedure. Okay, 129 we saw that it is a court, high court, which gives out the procedure for itself when it comes to original jurisdiction. 130 speaks of powers of other high courts to frame rules for one particular high court. Okay. And that will not be regarding the procedure. Make with respect to any matter other than procedure any rule which a high court for a state might, under Article 226 of the Constitution, make with respect to any such matter for any part of the territories under its jurisdiction which is not included within the limits of a presidency town. Now, presidency town, you have the provincial towns, all these are not there nowadays. Okay. So, you don't get confused over that. Okay. So, power of the high courts, of course, no other high courts can frame rules as regards the procedure to be followed in other high courts, right? But there are certain powers which are given to the other high courts to make rules other than for procedure. Okay, under under Article 227 of the Constitution. Section 131, publication of rules. All of you know it should be published in the official gazette. Part 11, miscellaneous. Section 132, exemption of certain women from personal appearance. Which category of women shall be exempt from personal appearance? Wherever their culture or their customs put forth a rule that no woman shall make herself be present before a court or before others, whatever it is, In such cases, such person shall be exempt, such woman shall be exempted from personal appearance before the court. Nothing herein shall be deemed to exempt such women from arrest. Okay, in case there is a civil case which needs the arrest of a woman, then the family members or the woman herself cannot say that, no, no, I'm exempt from personal appearance, so I should not be arrested as well. No. Law takes its own course. Okay. Then, section 133. Exemption of other persons. Other persons, here we see those people who are there with special privileges. They cannot be arrested at any time. Okay? Sorry. The President of India, Vice President of India, Speaker of the House of People. Which is the House of People? Lok Sabha. The Ministers of the Union, Judge of the Supreme Court, Judges, okay, of the Supreme Court, Governors of State, and administrators of union territories. Then the speakers of state legislative assemblies, chairmen of the state legislative councils, ministers of states, judges of high courts, and persons to whom section 87B applies. That is ambassadors, envoys, all those people. Okay, so all these people are exempt from personal appearance before the court. Okay. Then next, where any person claims the privilege of such exemption and it is consequently necessary to examine him by commission, he shall pay the cost of that commission unless the party requiring his evidence pays such costs. Okay. So where the person, other than all these people who are mentioned here, any person who claims that the privilege should be given to him, he should not be arrested. He cannot be personally present before the court. And he says, I am also entitled to this privilege. If anyone other than those who are mentioned in this particular section wants to claim such privilege, then he shall pay such costs. Okay, that is what we do, even in the courts when the client doesn't appear. What does the judge say? The judge says that, over a period of time, if the party doesn't appear, then the judge says you have to pay so much cost towards non-appearance. Before placing the person ex parte, this is one of the penalty type. Not exactly penalty, it's a fine, right? Just a token amount is asked for. Then section 134, arrest other than in execution of decree. The provisions section 55, 57 and 59 shall so far as may be apply to all persons arrested under this code. So what is there in that 55, 57, 59? You can go back in the book and see. Okay. So whatever are the provisions, see one thing you remember, whether it is arrest in execution of a decree or for some other purpose. Okay. The person shall be kept in civil prison. That's it. Okay. Section 135. Exemption from arrest under civil process. No judge. Who are all the persons who are exempt from arrest? No judge, magistrate or other judicial officer shall be liable to arrest. When they cannot be arrested, it's not that they can never be arrested. They can be arrested. But when can they not be arrested? When they are going to the court or coming back from the court, or when they are sitting in the court hall listening to cases. These are the 3 times when a judge or magistrate or other judicial officer cannot be arrested. 2. Where any matter is pending before a tribunal having jurisdiction. See, any party which has to appear before a tribunal for hearing. Okay. And when they are appearing through their lawyers or other representatives who have to appear, when they are appearing before them, they cannot be arrested unless other than the process issued by the tribunal for contempt of court. So you can underline there what you have to underline, other than the process issued by such tribunal for contempt of court. So what you will underline? The phrase contempt of court. Okay. So any person who is appearing before a tribunal for any type of hearing, it can be evidence or anything like that, either by himself or through his representative, he cannot be arrested unless the tribunal has given an order for his arrest for contempt of court. 3. Subsection 3. Nothing in subsection 2 shall enable a judgment debtor to claim exemption from arrest under an order for immediate execution, or where such judgment debtor attends to show cause why he should not be committed to prison in execution of decree. Judgment debtor cannot claim, no, please don't arrest me, I am just giving you an explanation, please wait for the explanation. No. Okay, he can be arrested. Section 135A, exemption of members of legislative bodies from arrest and detention under civil process. We have already seen they are exempt from personal appearance, right? So here we are seeing about arrest. No person shall be liable to arrest on detention if he is a member of either House of Parliament, Legislative Assembly, or Legislative Council of a state. So if he is a member of Parliament, if he is a MLA, if he is an MLC, or a Legislative Assembly, if he is a member of a Legislative Assembly of a Union Territory. Okay. Then share it during the continuance of any meeting of such House of Parliament, or as the case may be, of the Legislative Assembly or the Legislative Council. So where there is a meeting going on, where there is a meeting going on of the MLAs or MLCs, they cannot be arrested during that period. Same like, how when the judges are going and they are coming back or they are sitting in the court hall, they should not be arrested. Same way, MLAs, MPs, MLCs cannot be arrested when they are in the meeting of the Legislative Assembly or Legislative Council or the Parliament. Not in any other meeting, only these three. Clear? Then, if he is a member of any committee of either House of Parliament, or the Legislative Assembly of a state or Union Territory, or the Legislative Council of a state. So, member of a committee, you have, 2-3 committees, right? You have accounts committee, you have a sitting, a statement committee. You have so many committees like that, right? So or maybe committees are set up for specific purposes, that is also there. Okay. So when we are reading the constitution, we will get to know all those things. So if a member is a member of any committee, either of the Parliament or a Legislative Assembly or Legislative Council or Union Territory, even then he cannot be arrested during any meeting. When he is attending any meeting as an MLA or MLC or MP or as a member of a committee, then he cannot be arrested. Before and after he can be arrested. C. If he is a member of either House of Parliament or Legislative Assembly or Legislative Council during the continuance of a joint sitting, meeting, conference, or joint committees of the Houses of Parliament or Houses of State Legislatures, as the case may be, and during the 40 days before and after such meeting, sitting, or conference. Okay. It can be separate sitting or it can be a joint sitting of both Houses of Parliament or Legislative Assemblies or committees or whatever it is. Okay. And during the meeting, the person cannot be arrested. 40 days before the meeting, 40 days after the meeting. See, these are all done with a very fair view to give time to the person to implement his ideas or whatever he has thought about, planned, he can put it before the Parliament or Legislative Assembly or Legislative Council. This is only with a pure, fair intention that this provision has been made. Okay. Then subsection 2, a person released from detention under subsection 1 shall, subject to the provisions of the such subsection, be liable to rearrest and to further detention to which he would have been liable if he had not been released under the provisions of subsection 1. That means what? Subsection 1, I'm sorry, today a lot of problem with my throat. Subsection 1 deals with when he cannot be arrested. When can a person, whether a member of a committee or a parliament or MLC, MLA, when can the person not be arrested? That's what subsection 1 speaks, right? And what is common in subsection 1? Meeting. Okay, it can be only specifically to that particular legislative assembly, or it can be a joint sitting, whatever it is, it speaks about exemption from arrest. So same way, when a person has already been arrested, he may be allowed to be released during the meeting. And of course, again after the meeting, that is before 40 days and after 40 days. Am I right? So before 40 days, he may be released. It is not he should be. He may be released. And again after 40 days, he may be arrested. Okay, re-arrested. Clear? Then next we go to section 136. Procedure where person to be arrested or property to be attached is outside district. Outside district means what? The court which has taken up the case is in one district, but the property or the person who has to be arrested, the property to be attached or the person who has to be arrested is in a different district. Okay? Where an application is made that any person shall be arrested or that any property shall be attached under any provision not relating to the execution of decrees, such person resides or property is situate outside the local limits of the jurisdiction of to which the application is made, issue a warrant of arrest or make an order of attachment and send it to the district court of that particular area. If it is, say, for example, if it is in Bangalore, okay, but the person to be arrested or the property to be attached is somewhere in Raichur, clear? Then the court in Bangalore has to give a arrest warrant or an attachment, the decree for attachment, execution, right? So it has to give an execution decree. Whatever it is, it has to provide to the other district court. Say, in this case, it will be Raichur district court. Okay. Then subsection 2. The district court shall on receipt of such copy and amount cause the arrest or the attachment of the property. Clear? So, and what will be the powers of that particular district court which has received the request for arrest or attachment? The powers of that district court will be the same as that of the district court in Bangalore. Clear? Because now it has taken over the position of the Bangalore district court. Number 3, subsection 3. The court making an arrest under this section shall send the person arrested to the court by which the warrant of arrest was issued unless he shows cause to the satisfaction of the former court why he should not be sent before the latter court or for satisfying any decree that may be passed against him. Okay. So once the person is arrested, he can show cause as to why he should not be taken to the other court. Okay. Where a person to be arrested or movable property to be attached under this section is within the local limits of jurisdiction of the original court, okay, of the High Court of Judicature at Fort William in Bengal or at Madras or at Bombay, the copy of the warrant of arrest or the order of attachment and the probable amount of the cost of arrest or attachment shall be sent to the Court of Small Causes at Calcutta, Madras or Bombay, as the case may be. And that court on receipt of the copy and amount shall proceed as if it were the district court when it comes to Bombay, Bengal and Madras, that is Chennai. Okay. So Mumbai, Chennai and Kolkata. All these 3 places, wherever the arrest warrant or the attachment order has to be passed on, it has to be sent to the small causes court. and small causes court will be taken as the district court for the purpose of such arrest or attachment of property. Clear? We will stop with this. We will continue in the next class. Thank you.